Good afternoon. I'm Doug Eakley. I'm the co-director of the Rutgers Center for Corporate Law and Governance, and we are co-sponsoring this program with the Society for Corporate Law and Governance, which is the student-run organization that's a sort of a mirror image of our center, and I want to thank the students who are here helping us put this on. I don't think there's any more dynamic aspect of the American economy today than its entrepreneurial tech startups, creating more wealth and more jobs than just about any other sector. And of course, if you find areas of enormous growth and growth potential in the economy, there too you will find a thirst for lawyers who are adept at serving the needs of the tech startups. And we have two extraordinary people with us today who are also colleagues of ours. Their bios are in the program. Ted Weitz is, as we call him, the senior partner in our entrepreneurship clinic. Mukesh Patel is the director of development for the entrepreneurship clinic, and they are many more things and wear many more hats than those two, but that's why they let me drag them here today for this program. So I'll turn it over to Ted Weitz.
Thanks, Doug. Okay, our topic today relates to the financing of entrepreneurial ventures. Many of us have a well-established paradigm for that kind of financing. In some cases, it's based on experience. In many others, it's popular press and media. That's the vision that we see with Shark Tank and Silicon Valley, the social network, and on the less successful side, you may have watched HBO's brand new story about Theranos, the inventor, out for blood in Silicon Valley. There are significant elements of truth in each of these, but they apply to only a small subset of entrepreneurial ventures. We also should note that entrepreneurial ventures don't have to be in Silicon Valley. Yesterday's Wall Street Journal featured an article headlined, "Some Startup Ventures Leave Silicon Valley Bubble and Head East," noting that in 2018, New York City had 735 venture deals raising some $13 billion. So if you think you have to move west, that's not necessarily the case. But in any case, despite the attention, the overwhelming number of entrepreneurial ventures are not suitable candidates for venture financing and raise their money in different ways. We'll talk about that as well as venture-funded activities, but no activity, human or otherwise, takes place in a vacuum. As the environment changes, any organism in that environment either evolves or becomes extinct. The ecosystem in which entrepreneurial enterprises exist is no different. As it changes, the members of that ecosystem necessarily adapt to those changes if they are to survive. Some changes make the environment more friendly, some are simply changes to work around, and some may be obstacles that present large problems. The focus of my talk today will be on some changes in the legal and related environments, how they affect the ventures needing sustenance of the financial variety, and how those organisms are adapting to each of those changes. When a potential investor looks at a startup, one of the key inquiries is the degree to which the entity will be able to erect barriers to entry that enable them to maintain a successful competitive position. The germ of a startup is an idea, although many other elements are critical to success in the marketplace. Traditionally, one of the important ways in which ideas are protected are patents, and I see John Kettle from our IP law clinic sitting here who knows far more about this than I do. Patents are expensive to obtain, require expensive enforcement, and take time to acquire, but they can erect a major fence around the patentee, giving it a monopoly over the invention, even from independent development. As an aside, one of the great misapprehensions in the public marketplace is there's a moral component to patent infringement, that an infringer steals an idea. While that can happen, it's not an element of patent infringement. To continue with my movie list, a few years ago, Flash of Genius was all about the invention of intermittent windshield wipers, and certainly implied theft by the evil auto manufacturers who all started manufacturing these devices without paying royalties. The concept of independent development was soft-pedaled at best. Back in the 1930s, the movie The Alexander Graham Bell Story with Don Amici a movie in which the patent trial provided the dramatic denouement, which is incredible to anybody who's sat through a trial in a patent case, actually got it right, though. In the dispute between Alexander Graham Bell and Meucci over who invented the telephone, there was no issue of theft. It was simply a case that turned on independent development. Who invented the device first? But I digress. I started talking about patents for a specific reason. 20 years ago, investors placed great significance on the entrepreneurial company having patents. Things have changed a lot. Why and how? All intellectual property laws have always reflected a degree of compromise between conflicting societal goals. In copyright, it's the battle between an author's right to receive the fruits of their labors versus free speech. In patent, it is and always has been the battle between providing the incentive to inventors, to put time and money into research and development versus the desire to avoid society paying monopoly rents. The antitrust laws reflect our discomfort with monopolies, but patents are a clear exception. Every change in patent laws and patent enforcement adjusts the equation, and our process of doing that through erratic court decisions and random enforcement means that instead of making a policy by assessing its costs and benefits, we lurch from one decision to another, left with uncertainty and unexpected consequences. It's clear that court decisions, especially by the Supreme Court, have made it more difficult to acquire patents than was the case in the past. And I should say to acquire and enforce patents than was the case in the past. Historically, the United States Court of Appeals for the Federal Circuit was created to provide expertise and uniform results in patent cases, and mostly proved to be a very patent-friendly environment. The role of trolls, there's a troll for those aren't looking at patent trolls. The role of trolls, which is the popular term for non-practicing entities, has been one to help create an environment more hostile to patents. Patent trolls, for those who are not familiar with that term, are entities that don't practice the patents. They acquire patents, sometimes by manipulating the system, and then demand royalty payments from entities practicing in the field. Sometimes these patents have been of dubious validity, but the alleged infringer has a Hobson's choice. When the purported patentee is offering a modestly priced royalty versus the incredibly high cost and time investment of defending a suit and seeking to get a patent determined to be invalid or a determination that they're not infringing, defendants pay up, but they're pretty annoyed, and rightly so. The average cost of a patent litigation has been estimated at $1 million. The defendant has to add to that the uncertainty of victory. Is it worth it to fight? Often the answer is no. And even practicing entities have received very dubious patents. Although there have been some improvement in recent years and the standards have tightened, both as a consequence of the court decisions and the creation of a range of post-patent proceedings that can knock patents out, there's been considerable criticism of the process even today. Thus, in a recent op-ed in Ars Technica, Daniel Naser noted that Theranos was largely built on its supposedly great inventions. Their first provisional application, filed in December 2003, when Holmes was just 19 years old, describes medical devices and methods capable of real-time detection of biological activity and the controlled and localized release of appropriate therapeutic agents. This provisional application would mature into many issued patents, including the one on this slide. In fact, until very recently, there were still patent applications being prosecuted that dated back and claimed priority back to the original 2003 submission. As is usually the case, the examination in the patent office centers on whether the invention covered patentable subject matter and whether it was truly novel as compared to prior art. But nowhere in the process was there room for anyone to ask if it actually worked. As Naser wrote, in early 2014, around the same time that Theranos was beginning to grow its profile, the U.S. Patent and Trademark Office was criticized for awarding a patent to a Korean researcher for work that was already known to be fraudulent. The applicant had even been convicted for falsifying the relevant results. A patent office spokesman told the New York Times that the agency operates on an honor code and that patent examiners cannot independently verify claims. In response, Professor James Grimmelman commented, "The patent office is an armory handing out legal howitzers on the honor system. What could possibly go wrong?" I think that's an understatement. In part as a consequence of these developments, in recent years the Supreme Court's taken a lot more patent cases, and the results have constrained the acquisition of patents. Thus, while it was long established that laws of nature, natural phenomena, and abstract ideas are not patentable, in Alice, which is Alice versus CLS Bank, and several other fundamental patent cases, such as Mayo versus Prometheus, the Supreme Court set out a two-step framework for distinguishing patents that claim laws of nature, natural phenomena, and abstract ideas from those that claim patent-eligible applications of those concepts. The first step looks to determine whether claims are directed to a patent-ineligible concept. If they are, the second step is considered whether the additional elements recited in the claim transform the nature of the claim into a patent-eligible application by reciting an inventive concept that is sufficient to ensure that the patent in practice amounts to significantly more than a patent upon the ineligible concept itself. That may sound good to a few of you. I find it pretty confusing. And I think most patent practitioners and business people find it pretty confusing also. So the Patent Office itself, faced with the unenviable task of trying to reconcile the multiplicity of decisions in deciding whether a patent should be issued, came up with this crystal clear flowchart for examiners. My heart goes out to patent examiners. I should note this flowchart has now been superseded by an even more complex set of guidance. But cases keep coming, and the economic problem is well illustrated by a 2016 Federal Circuit case, Ariosa Diagnostics v. Sequenom. It's a case in which the patent applicants, after considerable research, discovered that a pregnant woman's bloodstream includes genetic material from an unborn baby. In light of this discovery, the researchers used known laboratory techniques to create a method to detect this genetic material. The genetic material, in turn, could be used to identify fetal characteristics, such as gender, as well as fetal abnormalities, such as Down syndrome. This invention avoided risks associated with prior techniques to identify fetal characteristics, such as taking samples from the fetus or placenta, clearly something that people value. But in Ariosa, the court concluded no patent could be granted because it was the discovery, and note that the word they use is discovery, not invention, of a law of nature and the application of well-known techniques. Regardless of your opinion on the merits, the decision will certainly diminish incentives for research in areas like this. Similarly, in Mayo versus Prometheus in 2011, the Supreme Court rejected a patent on a diagnostic test, holding it was simply a law of nature, and as Justice Breyer wrote, to transform an unpatentable law of nature into a patent-eligible application of such a law, one must do more than simply state the law of nature while adding the words apply it. That actually is clear. But what do we look at? You know, this is very esoteric, but it has very practical impact. The national debate on pharmaceutical prices, for example, plays right into this issue. The patent owner who has a monopoly granted by the patent is able to extract monopoly rents on the pharmaceutical. A narrow reading of what's patentable reduces the monopoly. But will the treatments or new drugs be discovered at all? The Martin Shrekleys of the world, jacking up prices while doing no research and development, evoke universal outrage. But the balance has two sides. The narrow reading of cases like Alice and Mayo and other cases will curb the enforcement of some non-meritorious patents. That's great. But it also creates uncertainty on whether particular inventions are in fact patentable. And so most interesting is the economic impact. What does this mean? Why does it have an economic impact? For the same reason patents were created in the first place. Patents were actually given prominent place in the United States Constitution as an enumerated power of Congress in Article 1, Section 8. Congress will have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Now, as my students know, there was only one president who actually held a patent, and it was Abraham Lincoln. And Lincoln said there were three most important inventions and discoveries to facilitate other inventions and discoveries. These were the invention of writing and printing, the discovery of America, and the patent laws. Now, he wrote that, specifically, he wrote that before the patent laws, any man might instantly use what another had invented, so the inventor had no special advantage from his own invention. The patent system changed this, secured to the inventor for a limited time the exclusive use of his invention, and thereby added the fuel of interest to the fire of genius in the discovery and production of new and useful things. Now, I don't quite rank patents up with reading. But who am I to argue with Abe Lincoln? It's a good question. But the theoretical value of patents in granting a monopoly to encourage investment is great, but the reality isn't always the same. Anecdotally, I've been told by a number of venture capitalists and investors that they're no longer as anxious to see patents in deciding whether to make an investment because of the increasing difficulty of enforcement and because technology moves so fast. My perception has been that the attitude prevailed in fields where there's a short development cycle and a relatively rapid approach to market. Things like smartphone apps. If it takes 5 years to get the patent through and the app is already obsolete by then, people aren't nearly as worried about it. But in areas where there's a large investment required, and especially where the outcome is not certain, my feeling was patents should remain important. Pharmaceuticals and medical devices, which require a major investment and long lead times, seem like perfect candidates. But that was my feeling, in part based on discussions with investors and companies, but not a scientific analysis. Fortunately, we now have a more objective answer, and it supports the dichotomy that seemed intuitive. An excellent brand new study by Professor David Taylor of SMU, rather than relying on anecdotes, did a full breadth investor survey. He asked some 475 investors how the changes in the patent laws and patent enforcement have influenced their investing practices. The survey results reveal investors' overwhelming belief that patent eligibility is an important consideration in investment decision-making, and that reduced patent eligibility makes it less likely that firms will invest in companies developing technology. Thus, 59% of investors either strongly or somewhat agreed they were less likely to invest if patent eligibility makes patents more difficult to obtain. And the impact differs between industries as well. For example, investors predominantly indicated no impact or only slightly decreased investments in the software and internet industry, but somewhat or strongly decreased investments in biotech, medical device, and pharmaceutical industries. So we have a strong idea that changes in the patent environment are redirecting investment. I have a client developing a medical device who complains that it's easier to get funding for an app that animates cute cats than for a life-saving medical device. To some extent, the changes in the patent environment aggravate this problem. A legitimate question is whether the social good is enhanced or harmed by restricting patents. Will investors continue to invest in and therefore enable medical testing devices, for example, if they're unable to exploit the fruit of that investment? And if they're able to exploit the fruits, is there any appropriate limit on that benefit? In the field of patents, it's often all or nothing. If you get a patent, you can exploit it as a monopolist. If you don't get it, it's available to the world. Should there be a middle ground that differentiates the profits based on the investment? Who knows? Policy discussions above my pay grade, but the impact is significant. And interestingly, the decision-making is being made without that impact being fully considered in a policy form, but rather case by case. Let's turn to a completely different change in the startup world. The securities laws and the fundraising environment. Here there are several developments of significance. Crowdfunding, ICOs, the growth of unicorns because of unwillingness to accept the burdens of going public, and some important tax changes. I'll try to touch on each as the time allows. The startup is, with rare exception, in a constant search for money. That startup may be incredibly well managed and financially disciplined, or it might be a harebrained scheme, which, despite the best intentions, will be a financial disaster for everybody who's involved. And as anyone knows, or should know, who's gotten one of those lovely emails explaining about all of the money sitting in an account in some foreign country, and they just need our help to get it out and will pay us 20%, there are an endless variety of scoundrels out there who want to relieve the innocent of their hard-earned money. The securities laws are an attempt, with mixed results, to balance these forces, to enable legitimate enterprises to raise money without excess cost, to reward the risk takers who invest, and to protect the sheep from being shorn. I'll start with my own. That's a sheep being shorn, by the way, for those. The securities laws I'll start with my own notion that those who invest in startups should really expect to be shorn in large part. VCs who do this professionally expect most enterprises to fail or limp along. They work, to the extent they work at all, based on the notion that even if most investments fail, the few home runs will balance that out. The retail investor who invests in one company is a lot like a roulette player, and their expectations shouldn't be too much higher. This balance is not new. Prior to the 20th century, the law was largely caveat emptor, and although fraud could be prosecuted, not easily, that was not much of a remedy for the fleeced investor. The states were the first to address this concern with a very wide variety of laws intended to protect investors. State securities laws are often referred to as blue sky laws because they attempt to regulate the sale of something that Justice McKenna in 1917 described as something that may have no more substance than so many feet of blue sky. As noted in the Hall case, whatever prohibition there is a means to the same purpose, made necessary, it may be supposed, by the persistence of evil and its insidious forms and the experience of the inadequacy of penalties or other repressive measures. The name that is given to the law indicates the evil at which it is aimed. That is, to use the language of a cited case, speculative schemes which have no more basis than so many feet of blue sky, or as stated by counsel in another case, to stop the sale of stock in fly-by-night concerns, visionary oil wells, distant gold mines, and other like fraudulent exploitations. We can take judicial notice that evil has not disappeared since 1917 and the enactment of the blue sky laws. In the 1920s, the overheated stock market led to widespread speculative investment by amateurs and professionals alike, and the 1929 stock market crash led to the adoption of the federal securities laws. These laws, primarily the 33 Act, the Securities Act of 1933, which dealt primarily with the issuance of securities, and the 34 Act, Securities Exchange Act of 1934, which dealt primarily with the transfer of securities and which established the SEC, still form the foundation of the securities regulatory scheme in the United States. And as those laws provided, the law is still that in most instances there's a dual regulatory scheme in which state blue sky laws coexist with the federal laws. So when startup companies want to raise money, they're faced with a problem. And the problem is that regulatory compliance is a very expensive proposition. The SEC itself has identified the average cost of achieving initial regulatory compliance for an initial public offering as $2.5 million, followed by an ongoing compliance cost once public of $1.5 million per year. As a result, for an issuer seeking to raise less than $1 million, a registered offering is simply not economically feasible, plainly not a viable approach for a small startup. But as we teach our students, and as I'll cover in tomorrow's lecture for those of our students who are here, there are only three ways for an enterprise to sell securities: pursuant to a registration statement, which we've already acknowledged is not practical, under an exemption from registration, or illegally. That's it. Obviously, the focus of smaller businesses has been on these exemptions. We also teach our students that the securities laws are generally malum prohibitum and not malum per se. So doing the right thing is not enough. You have to comply with the technical rules. Before I go into a little more detail on some of the developments, let me mention a very broad policy issue that's not discussed enough. Whenever we discuss limitations on the activities of a small enterprise that arise from securities laws, clients are inclined to say, why are these rules necessary? And I usually have two replies. First, I don't make the rules. I'm just reporting on them, advising what's permissible. And second, as Justice McKenna said, the public needs to be protected from the incredible array of people who would fleece them. My client's response is a simple one. Prosecute anyone who commits fraud, do public education that investing is risky, and then let people decide for themselves what to do. Why are we so incredibly careful with securities when we allow casinos to remain open? People will lose money in casinos, but there's no requirement we do elaborate disclosures or registration, or that only rich people can go into casinos. They're made as attractive as possible to the public, rich or poor, sophisticated or not. In fact, lotteries are not merely permitted, they're sponsored and promoted by the states. We don't think of gambling as an investment, but economically, it's no different, except for the odds. If we allow people to invest in mathematically certain losers, like lottery tickets, with almost no restriction, why should we constrain securities? It's an interesting policy question, but again, above my pay grade. The SEC and Congress have not been completely unmindful of the concerns of smaller entities trying to raise money. The federal securities laws contain a number of exemptions, the most important of which to the startup have been grouped in Regulation D, which is a safe harbor promulgated under Section 4A2 of the 33 Act. It provides several alternative means of raising money. There's also something called a Regulation A exemption, which is so cumbersome that it had almost never been used. The SEC said that based on SEC filings from 2009 to 2012, in that 4-year period, there were 22,000 plus offerings under $1 million relying on Regulation D, and 2 relying on Regulation A. Doesn't suggest that Regulation A is all that useful. There are also somewhat modified registration statements. Now, the SEC has recently modified Regulation A to make it somewhat less burdensome for smaller companies in what's popularly known as Regulation A+. But although there's been some success, it still requires leaping through considerable regulatory hoops, and it's not a panacea. Historically, the most important exemption has been Rule 506 under Regulation D, and the reason is because there's no limit on the size of the offering, and because there's no specific form of prescribed disclosure, so the issuer can use its discretion rather than following a detailed form of disclosure. And very important, because as a result of the National Securities Markets Improvement Act of 1996, it preempts most of the substance of state blue sky laws, so the issuer need not worry about multiple sets of compliance. But the offerings have within them a serious limitation, or serious limitations. For example, in a Rule 506 offering, the absence of a prescribed disclosure is only true if every purchaser is an accredited investor. What's an accredited investor? Individuals with substantial wealth who presumably are thought to be able to protect their own interests, many kinds of institutions, and executive officers or directors of the issuer. As another aside, the concept that merely being relatively rich, and they're not quite as rich as they were when the rule was first promulgated in society, is the concept that having that amount of wealth is enough to provide protection. It may be somewhat dubious. But until the Jobs Act in 2013 and its enabling regulation, there was no general solicitation or advertising permitted in any Regulation D offering, a serious limitation. Jobs Act, by the way, stands for Jumpstart Our Business Startups Act. There's a whole agency in Washington that comes up with acronyms, I think, even crowdfunding is an acronym, believe it or not. Today, there can be general solicitation and advertising of a Rule 506 offering, but only if all of the eventual purchasers are accredited and only if the issuer complies with enhanced verification of the accredited status of every investor. In a somewhat intrusive way, that can be quite a bit less appealing to many potential investors. If you think about the policy results of the no general solicitation and advertising rule, it's kind of interesting. Bernie Madoff successfully proved that rich sheep can be shorn as well as poor ones. But okay, assuming rich people are somewhat better able to protect themselves, there's another unintended policy consequence. A rich entrepreneur who went to the right schools, had lots of rich friends, was a member of the country club, he could get in contact with potential investors without general solicitation and advertising. He didn't have to take out an ad in the Wall Street Journal or write an infomercial. But a minority entrepreneur, someone who came from a less privileged background, how could they raise money, even with the same idea, even with the same execution team? Not by general solicitation or advertising. So what is the effect? The social effect may not be very desirable. Eventually, someone will come to almost every entrepreneur and give them a pitch like this. I know lots of rich potential investors. Let me go out to them and tell them about your company. It won't cost you anything. If I find you money, you can either pay me a percentage of what I raise or warrants in your company. I'm just a finder, not a broker. You will negotiate the deal. What do you have to lose? The entrepreneur always sees this as a good deal and asks for advice. And the answer is the securities laws have largely squelched that approach as well. The SEC has made clear that there is essentially no finder exemption. The activities just described are acting as a broker-dealer and require registration as such, which is extremely burdensome. In the absence of that registration, the test is factual, but compensation key to the success of the fundraise is an almost sure indication of illegal activity if you're not registered. Oddly, the find your industry is still operating, even though its activities are largely illegal. Perhaps it's because there's no one harmed by their activities. All in all, it does make it hard for the deserving entrepreneur to raise money. Meanwhile, as the internet developed, new ways of fundraising began to arise, in particular the method known as crowdfunding. Let me jump ahead. Crowdfunding could not be used to raise money via the sale of securities, and securities are very broadly defined. Crowdfunding could, however, be used to raise money for a worthy cause. What started as looking for charitable and philanthropic contributions soon morphed into fundraising for entities intended to be profit-making. And to the surprise of many skeptics, it proved to be highly successful for those entities that hit it big. Kickstarter is a perfect example. Kickstarter purports to limit itself to creative projects. Others are not so constrained. But Kickstarter says it has, as of last week, successfully funded almost 160,000 projects, raising over $4.1 billion. Of course, there have been even more projects that did not get fully funded, but 78% of the projects raised more than 20% of their goal and were considered successfully funded. The success of these campaigns led some to believe that since capital formation is a problem for startups, crowdfunding may be the cure. Let's allow people to invest in companies through crowdfunding, and small investors will get the opportunity to invest like rich people, and companies will have easier capital formation. This idea was popular with both political parties, a rare exception, and in April 2012, the president signed the Jobs Act. At the time, he said the following, "And for startups and small businesses, this bill is a potential game changer. Right now, you can only turn to a limited group of investors, including banks and wealthy individuals, to get funding. Laws that are nearly 8 decades old make it impossible for others to invest. But a lot has changed in 80 years, and it's time our laws did as well. Because of this bill, startups and small business will now have access to a big new pool of potential investors, namely the American people. For the first time, ordinary Americans will be able to go online and invest in entrepreneurs that they believe in. Of course, to make sure Americans don't get taken advantage of, the websites where folks will go to fund all these startups and small businesses will be subject to rigorous oversight. The SEC is going to play an important role in implementing this bill." So what exactly is crowdfunding? Will it be the hoped-for game changer? What did the legislation and the SEC do to balance the interests of ease of raising capital with protection for investors? And how does this fit with moves towards state crowdfunding rules relying on the exemption? After a considerable delay, the SEC introduced its rules. Crowdfunding is most commonly understood to be a means to raise money by enticing relatively small individual contributions from a large number of people. I personally am highly skeptical on whether giving small investors an opportunity to lose money on startups is much of a favor, but since we let Las Vegas prosper, why not? While the traditional means of raising money for a startup came under exemptions based on the premise that the issuance was not a public offering, as provided in 4A2, crowdfunding is precisely the opposite. It could not be more public. But far from being the panacea many thought it would be, offerings under the rules are in fact pretty burdensome for the small issuers it is supposed to benefit. First, the regulations, following the requirements of the Jobs Act, limit both the aggregate size of the offering to $1 million, now adjusted for inflation to $1,070,000, and the size of any individual investment using a sliding scale based on the resources of the investor. So if the investor's annual income and net worth are both below $100,000, the investment is limited to the greater of $2,000 or 5% of the annual income or net worth, and then there's a sliding scale. Every offer has to be made through a single portal, and portals themselves are subject to a significant qualification process, which I won't go into in any detail. All communications with prospective investors by the issuer must be made on that portal in a publicly visible manner so that potential investors get the benefit of the wisdom of the crowd, which I think makes a lot of sense because historically companies trying to get money would tell different stories to different investors, not necessarily a good way to accomplish protecting investors. But there are burdensome issuer filing requirements. In addition to the items we talked about, there's a requirement for updates, but also the issuer has to file its basic identification, names and prior job history for 3 years of every officer and director. the name of every 20% owner, a description of the business and business plan, the number of employees, risk factors, target offering amount, deadline for fundraising, purpose and intended use of proceeds in reasonable detail, a description of the offering process, the price to the public or how it will be determined, details on the offering and capital structure, et cetera, et cetera, et cetera. It's a lot of things that have to be done. As long as any of the securities, the crowdfunded securities, are outstanding, issuers are also required to file annual reports and update much of the original filing material. And since startups' plans by their nature frequently change, there's a need to update that information. Finally, there are extensive requirements for the portal as well. Although not nearly as burdensome as a full-blown registration statement, the hurdles and expense to an issuer for raising money through crowdfunding under the proposed rules are far from trivial. Those are the legal hurdles, but there are many other considerations. Some of those are not so appealing either. If the entity issues equity to the crowdfunding investors, they're shareholders. So the entity has to treat them as such, holding formal annual meetings, allow them to vote on election of directors or other matters, etc. That's a significant administrative burden for a startup. A second practical issue that is not trivial is that the issuer has to distinguish itself from the crowd clamoring for the investor's money. How do you do that? The usual way is to have a compelling video presentation, often professionally produced, telling the company's story. Again, not inexpensive and no guarantee of success. A third practical issue is that the equity investors may have unrealistic expectations. Institutional investors understand they're merely investors, not managers, and that many startups fail. Investors, no matter what the documents say, investors in crowdfunding may have unrealistic expectations of their influence, how entitled they are to information, and how likely the investment is to succeed. They will not all be Facebook. There will ultimately be plenty of failures. I've spoken to some institutional investors who say they will not invest in an entity that has previously done crowdfunding. Why? Because angel and institutional investors generally understand the risks involved in their investment. These experienced investors are concerned that crowdfunding investors who lose money will bring securities lawsuits, and these will be burdensome for the small company and everyone concerned. They have lots of places to invest, and this is enough to disqualify a company. Now that may fade as experience proves the risk to be lower than they're afraid of, or it may increase as experience proves their concern. Only time will tell. So how successful has equity crowdfunding been in its short life? According to crowdcrux.com, which I've not been able to verify, offerings increased from 178 in 2016 to 481 in 2017. Total investment grew from $27 million in 2016 to $49 million in 2017, the first full year of Regulation CF. So it's a start, but far from a revolution. Stay tuned. Moving on to another change, this is both a factor of the legal environment and the marketplace, and Mukesh will probably be commenting on this more, and that's the rise of unicorns. Unicorns, as you undoubtedly know, are companies that have achieved a valuation over $1 billion. They don't all look like this. That one belongs to my dog. They've achieved a valuation over $1 billion but remain private, no initial public offering. This is a relatively recent phenomenon. And many of these companies are very well known, primarily in tech areas. Uber, Envision, Joule, ZipRecruiter, to pick a few. Remarkably, Business Insider listed 47 unicorns in 2018. Quite a few have recently gone IPO or are poised to do so. Indeed, this week, Lyft's IPO is expected to value the company at as much as $23 billion. That would be second only to Facebook for a technology startup. And other IPOs of unicorns on the short-term horizon include Uber, Slack, Postmates, and Pinterest, which have all filed documents with the SEC to list their shares. Palantir, Peloton, and possibly Airbnb are expected to follow later this year. In fact, we're starting to see references to decacorns, private companies with valuations over $10 billion, a pretty staggering sum. To put it in context, a valuation of $23 billion, like they're talking about for Lyft, is roughly the same as the valuation of Fiat Chrysler, more than the valuation of KKR, Hartford Financial Services, CBS, or International Paper. But what does this mean? There are several important points about unicorns. First, the decision makers of these companies were able to raise enough money on the private market to decide not to go public or to delay it considerably over past practices. Second, the decision makers felt the disadvantages of being public outweighed the benefits. What are those advantages? First, there's the compliance burden, the time, cost, and effort of keeping up with all those required reports, of doing analyst calls, of being subject to the requirements of Dodd-Frank and of the NASDAQ or the New York Stock Exchange. And particularly important, the need to disclose material contracts and material events to the world. In addition, there's the pressure to make the numbers each quarter that can result in short-termedness. But as a company reaches the exalted unicorn scale, should it not be preparing to meet those standards? Is it free to operate without constraint? Under the securities laws, the answer to that is plainly no. Even exempt transactions are fully subject to the anti-fraud provisions of the securities laws. The SEC has begun to seriously focus on securities law requirements for anti-fraud protection, such as Rule 10b-5, in the context of non-public companies. Private companies often don't think about their obligation to tell the truth, but the SEC is beginning to forcibly remind them. Executives of private companies can be held liable for statements or other actions made in violation of the federal securities laws. One recent high-profile example where this happened is our friends at Theranos. These did take an awfully long time to catch up with the fraud. Another very recent SEC and Department of Justice case involved a company called Lucent Polymers, an Indiana-based company, in which the agency filed a civil enforcement against their CEO and COO, saying that the company's business model was a fraud. The company and its executives allegedly routinely lied to customers and falsified certification of testing data to create the impression that its products complied with customer criteria. The executives who were accused under the securities laws, not by the customers, but by the SEC. So it's something that, that can happen. And for those who think, well, if there's no harm, no foul, there's the classic case of In Ray Drummond, in which the general counsel of Google was disciplined because he allowed the company to exceed the Rule 701 limits. Rule 701 is the rule that allows you to issue options to employees and consultants and directors, but it has some limits in it. And Google, just before their IPO, exceeded these limits. No one was harmed. The people who received those options were enormously benefited by receiving those options. Most people before that thought, well, the SEC isn't really going to bother because there's no one to complain. But the SEC disciplined the general counsel of Google for that reason. And if you think that that's something that's passed, just this month, the SEC sued Credit Karma for the same violation, failing to comply with disclosure requirements under their equity plan. Interestingly, many of the unicorns are setting themselves up with a dual stock structure that assures the founders retain control even as they sell large swaths of the company. That's long been common in media companies. It's being increasingly questioned by academics and commentators, but doesn't seem to affect the only group that could most easily affect that trend, the investors in the inferior voting stock. Remains to be seen whether that trend will continue unchecked. And finally, I want to just very briefly mention ICOs. As you probably know, ICOs are what are called coin offerings, often coming up, the initial coin offering, essentially the sale of a coin, which is really a virtual coin, probably better called a token, which was the right to receive or participate in some future benefit. This is something that grew very, very rapidly, and an awful lot of money was made and lost in ICOs. But the SEC and courts have been very clear that the ones that provide upside and give the purchaser of the token any kind of opportunity to get involved in the upside of the company may well be a security. The leading case on this is a case called Howey versus United States in 1946. And the investment of money in a common enterprise with the expectation of profits to be derived solely from the efforts of others makes something a security. And the SEC has begun being more and more active in this area. There are a lot of recent cases on it, and it's something that I suspect will slow ICOs. In fact, I just read in Forbes that a study done on the accuracy of CoinMarketCap, which is a widely used resource for data on cryptocurrency, showed that roughly 95% of the volume of trading that was reported on the site was fake. what they reported $6 billion in daily volume, and a study of the actual exchanges in which the data was supposed to be based reflected only $273 million in actual volume. So cue the sheep ready to be shorn. I think I'm running over on time, so I think I'm going to turn it over to Mukesh without mentioning the other piece, and we'll be here for questions afterwards.
Let's see where they put it. Yeah.
My guess is if you go to file, maybe a recent one, let's see. It's a PowerPoint?
Yeah, so it should be minimized.
Let's just see if it shows up under recent. Nope.
Okay, so my name is Mukesh Patel, and it's a pleasure to be here today at Rutgers Law School, talking about innovation and capital trends, the convergence of intellectual, human, and financial capital. I'm going to take the innovator's perspective, the entrepreneur's perspective in this talk. So people recognize that change is probably the only constant in the world of business, and we call that level one of change. I do believe that we are now way past level one. In fact, with what the Industrial Revolution, or 4.0, that we seem to be in, I call it the fourth dimension of change as well: accelerating, exponential, and disruptive change. And this is permeating every sector, every industry, every company on the planet in some way, shape, or form. So part of the drivers of this accelerated, exponential, disruptive change are innovation advancements. And some of the drivers include HPCs, high-performance computing, also known as supercomputers, global broadband connectivity, cognitive computing, innovation platforms. You may have heard of SaaS, software as a service. There's also PaaS, platforms as a service, artificial intelligence, machine learning, blockchain, Internet of Things, also known as IoTs, data proliferation, or exponential explosion of data, material science, genetic engineering, automation and robotics and bots, and crowdsourcing and crowdfunding. I'm only going to touch upon a few of these with some interesting case studies and trajectory of where this innovation is going. So let's look at the world's population. We currently have approximately 7.4 billion people on this planet, and lately the pace of growth has been decreasing. So it turns out that in today's day and age, we add approximately 1 billion new people to this planet approximately every 12 years. That used to be significantly longer if you go back multiple decades. Now let's look at the number of internet users and the penetration of internet users worldwide for the period of 2014 through 2020. And we'll see that as we're approaching about 4+ billion people on the internet by next year, that represents about 55% of this population. So there's still significant growth and opportunity ahead. We also look at something like speed of broadband connectivity. 5G, for example, which has just started coming to the marketplace this year in 2019. And some of the important things of 5G that we should be looking at in terms of what capabilities it might have are things like capacity and latency, energy consumption, and costs. So you can see here that the latency is 1 millisecond compared to 4G, where it could be significantly more than that. Even things like peak data rates going from megabits per second to now 10 gigabits per second. And even the energy or the number of devices that can be powered efficiently and effectively through this kind of technology, you have 10 to 100 times more devices compared to what is capable today. So you look at the traffic that comes with this, 10,000 plus. You look at not only speed and throughput, but essentially something like, for example, a 2-hour movie that might take 6 minutes to download in today's technology will probably take about 3 seconds to download within a year from now. Then you have the world of IoTs, Internet of Things. These devices, just a few years ago, were approximately 10 billion devices, about 1.5 per person. And then by next year, the expectation is 50 billion plus devices, about 8 per person, including things like your automobile that'll have these sensors and devices that generate data, to healthcare or consumer electronics, even utilities. If we look at the curve of the explosion of the Internet of Things, you can see that it becomes exponential and disruptive at the same time. So one of the interesting things about IoTs is the amount of data that they can generate that people don't even realize is being generated. So let's just look at data growth, for example. Data is now not measured in megabytes or gigabytes or even terabytes. It's cumulatively or collectively measured in zettabytes. 1 zettabyte being 1,000 to the 7th power of exponential powers. So you can see this is also an exponential curve of data. Now what's interesting is that lots of technologists talk about proliferation such that within a 2-year period, more data is generated than in the history of mankind collectively. Well, whether it's 2 years or more or less, certain phenomena like Moore's Law is applicable here in many ways. If we look at 2015, the universe of data was perhaps approximately in the order of magnitude of 10 zettabytes, and by next year, maybe 44 zettabytes. But less than 1% of this data is actually analyzed in any meaningful, interpretive way. Today, we do have, with the power of large data, exponential data, and IoTs that generate that data, and artificial intelligence or machine learning that help analyze that data, we go from just descriptive analytics to predictive analytics to even prescriptive analytics, where recommendations get personalized at each human being individual level. If you look at what happens today, a company called Domo tracks this, and I've been tracking Domo's dashboards for a number of years now. We're now up to version 6.0, which is 2018. So about a year ago, and this is what happens every 60 seconds. So if you just look at a couple of things, like Amazon ships more than 1,000 packages every 60 seconds. YouTube, more than 4 million videos are watched by its users. Or you'll look at 120 new professionals connected on LinkedIn, Snapchat, Skype, Instagram, 50,000 photos generated by user posts. And this continues to accelerate exponentially, essentially every hour, every week, every month as we move forward. Then you look at the rate of change from a workplace dynamic. And it's interesting that although the building envelope of real estate changes approximately every 40 years, that's even starting to compress now. Workspace maybe 10, the workforce approximately 8 years. Organizational change happens every 3 years now. And technology every 1.5, which is essentially Moore's Law. The organizational change is very interesting because now more than 40% of the U.S. workforce are known as contingent workers or partially contingent workers. And 80% of corporations are trying to figure out how can they leverage this flexible giga economy or workforce that have these side hustles and create companies or create new innovative things. I'm going to take you down a quick memory lane and see how many of these companies or businesses do you recall and remember. Pan Am. So many people may remember that, and now we have lots of new airlines and airlines that have disrupted other airlines, and now we have new kinds of aircrafts, some that are in the news this week because of challenges and are being questioned. So there are things like how much information did people know about the aircraft, and then is it a pilot fault? Is it a training fault? Is it a country fault? Or is it a technology fault, or all of the above, or some of the above? Compact computers. You may have had this phone when you initially bought your cell phones. Or let's look at Kodak, which is an extremely important case study used in business schools around the world. They talked about 50 years of innovation. But let's take a look. A company founded in 1880 that had the digital photograph and the technology surrounding that as early as 1975. But because of the fear of perhaps cannibalizing their own business model or products or services, or other reasons, that complacency or status quo kind of kicks in, especially with organizations that get older or larger, they become the Titanics. Very difficult and to basically make agile maneuvers and to pivot in very incremental, fast ways. So in 96, a market cap of about $30 billion with 140,000 employees. 2012, they filed for bankruptcy with about 17,000 employees. The same year that approximately 13 employees under the age of 30 on average decide to launch a company called Instagram that gets a market cap of $1 billion and then gets acquired shortly after that. Or you may have been a customer in this business. Blockbuster. How could they not see it coming? Were they sleeping at the wheel, or was it a actual decision made that we can't disrupt our own business model? And the fear of disrupting your own business model basically leads to obsolescence. So we know the story of Netflix, another popular case study, where the founder was a Blockbuster customer, had to pay a late fee, and was angered by that experience and said there must be a better way. And so why not create an opportunity or a business model where there are no late fees? And in fact, the longer customers keep our product and don't return it to us, we actually might make more money because we don't have to utilize the postal service to keep sending them, and we can save on labor and material costs, shipping costs, etc. So a whole new paradigm of experience comes into the technology play as well. Today we call it design experience or experience design, and it falls within the realm of design thinking for new innovative business models. Or a company like Borders, perhaps, where you may have spent some time. Circuit City, Radio Shack. And to think about Radio Shack as a place where innovators actually went to buy their little toys and trinkets to actually create and build itself goes out. Or Fortunoff, Sears. And if we just look at brick and mortar retailer market values of 2006 versus approximately 10 years later, we'll see that you see a column of reds except for two, Walmart and Amazon, amongst the big prominent players. In fact, if you create a bar graph, you'll see that in terms of market cap, there is a significant disallocation or disproportionate effect of new players always thinking about new innovations and trying to disrupt themselves before others do. Just today on the news, on the way here, I was listening to a Bloomberg story on Bed Bath & Beyond. So if you think about Bed Bath & Beyond, are they next in line? In fact, if you look at their stock valuation over the last several years, it's been declining approximately 50% per year, plus or minus some standard deviation. And you look at what do they sell? Who do they cater to? Who actually goes to Bed Bath & Beyond, and what's the experience like? So they're trying a lot of different things. They sell lots of different products. In fact, I think the current CEO of Bed Bath & Beyond is a Rutgers alum as well. And we had the privilege of hearing his talk about the journey and the challenges. And it's no easy challenge to overcome. So the next question is, what happens to companies like Bed Bath & Beyond. Of course, when they initially launched into the marketplace, they had the advantage because their competitor, Linens and Thing, got disrupted and went out of business. But now, who else is in line? And so you have to kind of think through that. Despite all of this, and despite e-commerce, online retailing still only represents less than 20% of the entire retail market. So there's still a huge runway, even in the retail space, but everything is changing. Even the footprint of what does the real estate for retail look like and what can it become. I've seen lots of high-end banks that have vacated, turning into clothing stores or restaurants. And then you have to imagine, just look at the bank footprint, the number of retail bank branches. I took my daughter, who's a freshman in college at University of Pennsylvania Wharton School, and we did this case study. I said, come with me to the bank. I'm going to do a transaction. And then I'm going to ask you a lot of questions about what you think and your experiences from this. And it was probably the first time that we actually walked into the bank together. And we walked in, the whole experience, we were trying to do a favor for her grandparents who were traveling to do a transaction. And we went to a pretty large retail bank outlet, which I won't mention any names. Went in, we sat down, the coffee was very cold and did not, the machine didn't quite work. The TV did not work. There were old magazines that nobody really cared to read. We waited for someone to come and acknowledge us. Finally, when that person came about 15 minutes later, they brought us to another holding pen just 20 feet away, waiting for the next representative to show up. When that person showed up, sat us down in their office. So that was our third location now within the same branch. We sat down. They powered up their PC computer, perhaps from the compact days, because it took another 5 minutes for them to get to the right screen with some glitches and frozen screens along the way. Finally, some photocopying happening, our transaction finally being done. They give us copies and asked us if we need anything else. And we walked out about 47 minutes later. And I asked my daughter, so what'd you think? That's our banking at its best with one of the most prominent banking institutions in the world. And she said, Dad, why would you ever do that again? That was so painful. And I can't imagine that you need to do this for anything. And so, of course, she was the first one in our family to do all scan banking transactions and electronics before she even turned 18, had everyone using it and doing it, and now essentially looking at the new kind of bank. So if you've seen the latest commercials from a bank like Capital One, for example, their spaces are being transformed to look like co-working spaces and internet lounges and kind of places where people have conversations about doing business as opposed to the banking transaction. It's like more like a cafe. But then you have to think about banks that have no branches, like complete internet-based banking. And where does that go? Or you think about things like fintech, which I'll talk about in a minute as well. So if you just compare some of the examples of like hotel chains versus Airbnb, a company when it launched by 3 young co-founders, everyone essentially said, this is a terrible idea, will never work. In fact, it's too dangerous. Who would want to stay in a stranger's home, bed, couch, or extra spare room? Or you look at things like strangers driving you just because they have a car and their vehicle is certified, for example. Coming back to WeWork, which Ted also talked about. So everywhere I travel around the world, if I ever see a WeWork or its competitor, I always go inside just to see what's happening in the space of innovation and kind of who's in there and what's going on. WeWork is pretty interesting. In fact, one of my prior startup companies called Juice Tank was a competitor of WeWork, and I learned about WeWork only after we had launched. And we actually recruited a lot of interesting startups from WeWork, from New York and other places into our space, including Silicon Valley, coming to New Jersey. Now, anytime being in New Jersey, if you can attract somebody from the West Coast, that's considered a win, because typically we'd lose our next generation to go to the West Coast. However, WeWork, being in New York City, had access to capital, and they had an interesting business model. Today, they are growing at such a fast exponential rate. I think, if I recall the statistics, there is a new WeWork space, co-working space or building, a facility, coming up somewhere on this planet every 72 hours, approximately every three days. And their goal is to get to one close to every 24 hours. That's remarkable. However, valuation is very different than profitability. And so just like the Lyft example, they're losing money. In fact, they lose more money with every new location they open up. How can that be an interesting business model from a financial point of view? However, just like certain companies like Amazon that were not profitable until a long period of time, or came up with diversified businesses such as AWS, Amazon Web Services, and now Amazon Go, there are opportunities to expand and proliferate even within business models as well. How many of you have been to an Amazon Go store? Just by raise of hand. Oh, no one in this room. Okay. Perhaps some of the people online have. So when I was in Chicago, I went to one. It's fascinating what Amazon Go is capable of doing, even in the retail space. If you haven't been to one and you happen to see one, go inside and check out the experience. If you haven't been to a WeWork or one of its competitors, go inside, start talking to folks or interviewing people, and just get a new lens or perhaps an appreciation for how some of these dynamics are happening in the marketplace. Another one, of course, Elon Musk is in the news, perhaps not all the time for positive news, sometimes negative news, and the pressures of SEC and the I guess, perpetual battle. I don't think that battle will ever end until one of them dies. And so if you think about, so I've never met Elon Musk, but I have visited his Tesla plant in California and interviewed a lot of executives and engineers. And it really was an interesting case study of how someone like that, who was not in the automotive industry, can cause such a exponential disruptive impact across automotive companies around the world. They weren't moving fast enough to bring efficient, autonomous electric vehicles to the marketplace. And so the notion of status quo and complacency kind of kicks in. He starts this company and essentially funds a significant amount himself. Of course, he has huge investors as well. But it was all about like how they thought about cars. So when the engineers were talking to me, they would ask me, Mukesh, who do you think we are targeting as our customer? And the first instinct was someone was looking for an autonomous or electrical vehicle. And their response was no. They are targeting whoever is interested in purchasing a vehicle to be the best vehicle in the world. And footnote, it just happens to be electrical and capable of autonomous. So you think about that, and it's not even about the electric. It's not about autonomous. It's really about the experience and the data that comes from it. So if I were to look at Tesla today going forward, they're really not a car company. They are a data company, a data technology company that can do amazing things. And in such a short period of time, we're talking about a car that ends up being one of the fastest consumer cars in the marketplace and one of the safest cars in the marketplace, capable of doing new things. But what happens, so I talked to the chief innovation officers of multiple car companies and realized that they've set this spectrum called 0 to 5, 5 being we're fully autonomous in the marketplaces. So we're probably somewhere approximately in the middle right now. But the guess is that there's so many experiments going on with autonomous trailer trucks to cars to other types of vehicles that before we know it, this will be the norm. And my son loves it and hates it at the same time because he's a car guy. And he's worked for car companies and, went to University of Michigan, the home of like the automobile industry, and he loves to drive. Before he even had his permit, he had won a brand new car in a competition. And so that's a car enthusiast like in his blood, in his DNA. And he's like, Dad, I see what's going to happen. The HOV lane is going to be where if you want to actually drive your car, you go into the lane where a human being can drive, and you're going to have to pay to drive because all the other lanes are going to be autonomous. So he's trying to figure out how do you slow down the autonomous vehicles, not because he doesn't love them, he loves the cars, but because he still wants to drive. And who knows if drivers will actually be permitted. But then the impact of autonomous vehicles goes into everything from like traffic lights. Like what happens to every traffic light in the world? Because it needs to be repurposed, or perhaps needs new timers and new sensors, and here's more IoT devices generating more data. What happens to repair shops? Because if you think about a Tesla, or now every car company, I think Volvo just announced that starting next year, I believe, almost all of their cars are going to be electric, and Audi's doing the same, and Mercedes and Lexus. Even Porsche has their Taycan car that's about to roll off into the marketplace. But what happens to like repair shops? Because these cars, the motor or the engine is really small, tucked away behind like the back seat in the middle. It's really just like a gearbox. And then you have the chassis of the car, which is like 7,000 cells of battery. And so as battery technology or material science changes, autonomous vehicles come into play. Now, repair shops, is there such a thing? Superchargers. If you can charge your car in 5 minutes flat from your own home or anywhere you go, what happens to gas stations all over the country? Then what happens to insurance? The next generation, the millennials or Generation Z, do they even want to own a car? Most of them just want to be able to call one on demand, change it every hour or every day. Like, why drive the same car for more than a day? If you can keep driving different cars and different experiences, that's what they're looking for. And so if you don't own the car, then who's liable? Is it the human being in the car? Is it the car manufacturer? Is it the software developer? Is it the code or whoever developed the code to it? And there's lots of ethical considerations as well, not only in this space, but especially in genetic engineering. So if we look at Moore's law, which is essentially the number of the computing power that can double every, let's say, 18 months or 15 months. Sometimes it feels like it's getting compressed. Used to be 2 years on average, to like the speed and the cost of that computing power going to half in the same time period. And we map Moore's law with the cost to do a genetic edit or a genome edit. Used to be about 18 years ago, about $100 million. And then somewhere in 2008, it broke the paradigm or the sound barrier, as I call it, to become about $10 million. All the way down to about 2008 or 9, about $1 million, to now where it's literally several $100s to do this. And there's lots of companies that you may have heard of. What are they doing with all those saliva kits? The thousands and thousands, if not millions of saliva kits that people are ordering and then sending back so that you can figure out your ancestry, or you can figure out like what kind of genetic code you may or may not have and disposition to what diseases, etc. You may have seen in the news recently about a company in, I think it was in China, where they're actually pushing the envelope of, just because it's technologically feasible and capable does not mean that we should push that envelope too far. We need to think about the ethical ramifications and implications as well. But there's companies like CRISPR or technologies like CRISPR, which are enabling some fantastic, amazing, personalized, customizable medicine. Or talk about conferences. I was giving a talk at Mount Sinai Hospital Network, and I met the chief innovation officer, who's a physician as well. And he runs the digital medicine conference, where all these thought leaders come about and they talk about the future of medicine and how doctors and entrepreneurs and innovators and academics can work together in public-private partnerships to do a more responsible digital medicine platform, where essentially the medication you take will be extremely different or slightly different or nuanced from the medication someone else takes, when today everyone gets perhaps the same medication and the same dosage. But people's bodies are different and people's reactions are different. So if we think about even medicine, There are now pills with digital cameras, wireless technologies that you swallow, and they can go through your entire inside and capture tons of data to feed to like the Watson platform, so it can help analyze things that doctors cannot even imagine today. Or space flight. And so essentially, historically, it was only governments or organizations like NASA or orbital science that were entitled to or capable of doing any kind of space flights. Now we have these entrepreneurs that are somewhat self-made rocket scientists in some way, shape, or form. Everything from Jeff Bezos at Blue Origin to Virgin Galactic by Richard Branson, and of course Elon Musk with SpaceX. And now reusable rockets coming back to the exact same launch pad as a landing pad in reverse trajectory, phenomenal. And then you start thinking about this. So I made a list of some interviews I wanted to do with astronauts, and I actually had the privilege of meeting 4 living, well, I guess they're all living, otherwise I couldn't interview them, 4 astronauts. And really, it's crazy to think about where we are today and where we're going compared to when they took space flight to explore and discover. By the way, it's crazy how many things are floating in space that are man-made. We think there's enough junk in the waterways on the blue planet. There's a lot of junk in space that human beings have actually left behind. And so the question is, what happens to all that junk as well? Ted talked briefly about crowdfunding, but there's also this element of crowdsourcing. And so I see that we have a colleague, a friend of mine, John, who graduated from Rowan University. He's a tech entrepreneur here. And he started an interesting tech startup company called Stunited, which, when I think about it, is really leveraging crowdsourcing. That kind of technology that he's working on can apply to academic spaces or corporations where, let's say, you have thousands and thousands of employees or human beings. How do you connect them with things that matter to them? So, like, for example, supply and demand of skills or knowledge that someone wants quickly, efficiently, with great user experience. How do people find one another? When you have 50,000 employees or 100,000 employees, it becomes really difficult. And so he's leveraging those technologies to basically barter intellectual assets and skills, which is fascinating. But then you can crowdsource other things. Like there's a Dr. Peter Diamandis who's affiliated with Harvard and MIT. He is a serial entrepreneur, a physician, and an engineer. And he started something called the X Prize. I had the opportunity to interview his new CEO in Washington, D.C., where he said, imagine incentivizing the crowds to solve really tough challenges that teams or companies cannot solve, or the most advanced researchers cannot solve. So it's the idea of bringing diversified thought and intellect from people around the world that don't know each other. So National Geographic experimented. They couldn't solve a problem with all their research scientists and experts. They unleashed it into the crowd, and these young people from around the world working together in teams they've never met. They don't even know each other's names, and they collectively solve the challenge that National Geographic could not solve internally. Or X Prize put out a challenge. Usually starts with $1 million, but can go up to several $1 million. A new technology or innovation to clean the ocean waters from human debris. And experts in that space couldn't solve the problem, and some young tattoo artists in Las Vegas essentially solved the problem and won the X Prize. And so things like crowdsourcing. So imagine if there are platforms, there currently are, but everywhere. And if it becomes ubiquitous where companies can leverage crowds to solve challenges that their own employees can't. Just because you have 500 employees or 5,000 or 50,000 doesn't mean you don't have 7 billion people who can maybe help you solve problems without being in your office space. Then we talk about social networks. So you may have heard things called 6 degrees of separation, the Kevin Bacon, journey of any movie he's in. If you actually look at everyone who's in the Kevin Bacon movies, who else does he know just by those connections? There's actually a website that you can go to see who Kevin Bacon is connected to, any other celebrity, and then how you might be connected to them as well, even though you may have never met Kevin Bacon. So several years ago, I wrote a thesis saying that this can't be true anymore, that we have way too much technology and innovation for 6 degrees to still apply. I wrote the theory of 3.x, somewhere between 3.1 and 3.9, and it turns out Facebook did a big data study that it's about 3.5 degrees of separation between users, and in the real world, outside of the digital space of social networks, it's only slightly more than that, averaging still approximately order of magnitude of about 3.5, 3.7. So imagine 7.4 billion people crowdsourcing and just 3.5 persons away from anyone on this planet. What can you achieve or accomplish? Then we look at things like unicorns. And so Ted talked about unicorns and something now called decacorns. I wonder if we'll ever break decacorns into the next power of 10 during our lifetimes. I don't know, but don't say impossible just yet. So we currently have about 326 private companies valued at 1 billion plus on this planet. Approximately half, or a little less than that, approximately half are born in the United States. That used to be about 80% when I started covering this data only 5 years ago. And now we've slipped from 75, 80% down to like 47, 48% perhaps. For the first time in history, just within the last 6 months, I believe, or no more than a year, China now has generated more unicorns than the United States. And so, and about 50 out of the 150 of the US were in the last 12 months alone. So just look at the accelerated pace of even generating or birthing unicorns, for example. And we talked a little bit about the companies that are about to hit the market in IPOs. We mentioned a few of these companies. But you look at something like Slack, for example. Very interesting, simple, like what started as an MVP or a minimum viable product. And for internal use, people loved it. And now even companies like NASA use it to put the rover on Mars. And how companies like that become multi-billion-dollar enterprises. Part of it is understanding like the Silicon Valley, or what I call Silicon Valley Alley model. So at Rutgers University, headquartered out of Rutgers Business School, I'm launching an initiative called Journey to Silicon Valley Alley Model. It's part of a bigger idea called Venture Labs, where we want to connect Rutgers University to innovation and tech hubs throughout the country so that we're not living in a bubble or in a microcosm. We're actually part of the network of innovation hubs. Also globally, like where's the growth and where's the decline of tech hubs and innovation hubs globally. So we're trying to then plug into the global network as well. Not only Rutgers, but collaborating with universities, collaborating within schools of Rutgers and with other universities, public-private partnerships with corporations, nonprofits, government agencies as well. And then what are the interesting trends in terms of growth sectors? There's at least 16 that are currently commanding a lot of the venture capital money globally. And so you have everything from cybersecurity and digital health, big data, internet, hardware, software, mobile, even real estate tech, legal tech, energy tech, food tech, beauty tech. Essentially, take any traditional industry and just add the word tech or innovation to it, and you've got a whole new space that's coming around right now. So here's another example. We have another colleague, Kiran, in the audience here today. He's a computer programmer, computer scientist, who finished his master's recently. And he's done a few tech startups, but the latest one I found very fascinating. And just recently I became a partner of his in his business. And CodeBot is interesting. So, and the potential is probably bigger than we can even imagine today. But the essential concept is CodeBot AI. You dictate in natural language, right now English, but it can perhaps be any language in the world, an input, like what specifications do you want or need? And so just speak like a human being, perhaps voice entered or text entered, or you can upload a document or even a drawing. And once you enter that, that's the input. Instantaneously, within a second, comes the output. And the output is code. Code in the form of languages such as Python and Java today. And what's interesting is, while it's not currently designed to be complete code or comprehensive code, it is a starting point for a concept that perhaps can become a major innovation with multiple business use cases and impact as well across the board. So we're just trying to envision what could this be applied to and what use cases might have it. And so we're about to go on our journey for venture capital money and apply to accelerators. So there's things called incubators, accelerators, innovation labs, and co-working spaces. Some of them kind of now blur the lines. Others are fairly distinct. So I travel the world studying that space of these innovation labs, incubators, accelerators, and co-working spaces. We're applying to Y Combinator. YC is probably one of the most, if not the leader in accelerators globally. In fact, it is probably, if I had to guess the numbers, based on their admission rate, probably 500% harder to get admitted into Y Combinator than to Stanford, Harvard, or MIT, or fairly close to that in the same order of magnitude. So you can just imagine if we're seeing the scandals of getting, wealthy celebrities getting their kids into colleges these days, what might be next? People paying millions of dollars to get into YC, perhaps? Who knows? So what about innovation or innovative disruptions in the legal space? It's coming. It's already there in small bite sizes today. Things like discovery or document review, document production, assembly, things like applications for certain, perhaps even patents or trademarks, the content that goes behind it, things like due diligence, analytics, and applications. But some of the recent ones are things like smart contracts. So I came up with an idea for an innovation in this space, and I pitched it to senior partners in major law firms. And I brought along with some of my CTO friends. And the one thing we noticed is how all these senior partners basically said, that'll never work. And they had this almost like an upset, angry face. And they would say, this will never work. And when we walked away from those meetings, my CTO advisors, who are pretty prominent CTOs formerly from public companies, said, we're onto something. And we know that's validated because no one in the space wants to believe it yet. And so part of my thesis was a smart contract that's like 10x what most people think about smart contracts today. Can you imagine contracts being generated, managed, authenticated, executed, negotiated, shared, archived, leveraged for litigation or litigation avoidance, alternative dispute resolution, which people mostly think about mediation, arbitration, or MedArb, some hybrid form of that, but now new versions of dispute resolution, all through a smart contract platform. And then the lawyers get involved for where it takes more thinking and intellect power, not for basic things. And then what might it do to disrupt companies like arbitration services? Or how could it disrupt the court docket that gets so backlogged because of, we know that about 95 or 98% of the cases settle in litigation, approximately. Well, if they're all settling, and some of them settle very quickly, especially small claims cases, 30 days, 60 days, 90 days, 1 year, do they need to clog our court system and use taxpayer money? And so leveraging innovative, disruptive technologies could perhaps solve many of those things. Just today, I learned this morning through a newsfeed that I subscribe to on innovation that in the country of Estonia, which is thinking of ways to automate government services, their newest one is a bot that will settle small claims disputes instead of a judge. So essentially replacing a small claims judge in the process. And then if you're not happy with the resolution, you can then pay for and opt to actually go before a real human being judge. So the applications are coming in so many different ways. There are firms today that will give an entrepreneur their entrepreneurial legal toolkit, let's say the first 10 documents that they need, through their autonomous document generator online for free, that maybe 5 years ago I used to pay $10,000 for that same set of documents. And of course, you're not getting a human being, but then think about things like fintech or the application in other spaces. So even like AI, with AI bots and vision, auto, robotics. Let's talk about fintech for a moment. So most people said that no one would want to invest through a bot. They would want to invest through a human being financial advisor. But now you have companies like Betterment that have disproved that theory and growing significantly fast, exponentially. And now you've got other companies that are teaming up. I mean, just look at electronic payments and currency. And lastly, credit cards. Like, do we need credit cards? And are there ways to actually undo with no currency and no credit cards and still being able to purchase what you want safely and securely? So just this week, Apple announced their partnership with Goldman Sachs and MasterCard, I believe. And I've met co-founder of Apple, not Steve Jobs, but the other co-founder, the other Steve, and the president of Goldman Sachs previously, and asking them questions about what's possible. But never did I think that these three companies would actually come together to launch the Apple Card or the Uber Card, which has also come out to the marketplace. What's interesting about the Apple Card is that it basically takes the things that people hate about credit cards and just does away with it, that all these credit card companies will never be able to get to because it's too painful from a disruption point of view. So think about if you have a cashback reward in your credit card. It could take months before you see that cashback. Even some cards say 1% when you buy and 1% when you pay is when you get it. Apple will get you that cash in your account same day, that cashback, and it's 2%, which is interesting. And then they probably have perks so that if you use other Apple services, it's even more. But no fees, no late fees, no international fees. Like, they are really thinking about how to disrupt that space as well. And I imagine a day where there will not be any plastic at all. In fact, if you apply for an Apple Card, I'm not endorsing it. I'm just saying how different it is from an innovative point of view. You apply online through your phone, and you get it within minutes, the digital version, and then you get the physical one within a couple of days. So you can start using it literally within 10 minutes of applying for the card. Why would the Z generation want anything different, where you have to go fill out a paper form or, wait for weeks, things like that? So I leave you with something to think about. 40% of Fortune 500 companies, are they at risk for being displaced, replaced, bankrupt within 10 years? If we look at the adoption curve of getting to 50 million users, radio took 38 years, TV 13, the iPod 4. Pokemon Go took 19 days. Go figure. Or what's the S&P 500 list? What's the lifespan of these companies? It used to be 61 years in 1955. Today, it is approaching approximately a dozen years. And so really need to think about this curve as well. And I love this article from the Harvard Business Review. Under innovation, the C-suite needs a chief entrepreneur, because we need to disrupt ourselves in order to sustain and survive. Otherwise, someone else will do it. And so this notion of a chief entrepreneur is someone who reports directly to the board of directors and not to the CEO, to give them independence and a runway to experiment with innovation. And they collaborate with the CEO. And so with that, thank you very much for your time, and hopefully there were interesting thoughts to think about.
That was great. We don't have time for questions and answers in this room, but we have a reception set up on the third floor atrium, just up the stairs 2 flights. And I know that Ted and Mukesh would be delighted to field questions and engage with you up there over a glass of wine or a soda or some snacks. So thank you very much. This was great and greatly appreciated.
Thank you.
Terrific. I'd love to. Can I get a copy of your PowerPoints?